Mr. Vogel, can you give us an update on whether we have quorum?
We do, Mr. Chair. Of the registered members, we have you, Ms. Evans, Mr. Irvin, Ms. Kaser, and Judge Kulak here, along with Mr. Sandoval, who I believe would count as a guest now, but we do have the 5 members needed for quorum.
Wonderful. And what then we need to do just real quickly is, I guess our last meeting of the disqualification subcommittee was 1 week ago on the 11th of October. Mr. Vogel has posted those meeting minutes on the website. If people have had an opportunity to review them, does anybody have any concerns, recommendations, or proposed changes? Seeing nobody's hands raised or concerns of any type, I'm going to adopt those meetings as posted.
So if everybody could mute themselves, then wouldn't get all that feedback.
Yeah, that was a weird one. Okay. So moving forward, what we're going to do today is we have one last item that we need to open up for discussion and before our recommendations go to the full task force. The issue that we have remaining essentially is which case or which disqualifying crimes should no longer be disqualifying crimes, and should there be some that move from, let's say, the 15-year to the 5-year. Mr. Vogel and I had a quick discussion off the record prior to about just structure for today. I don't think it makes sense to go through every single thing listed, but the idea that we have is going to be similar to what the 2008 legislative task force did, where it said it concluded that there were some offenses that did not need to be disqualifiers, that there was not a link between public safety and safety of vulnerable individuals and the crime, and gave some examples. And then I think the second part of that is if there would be some matters that are felony offenses that shouldn't drop and no longer be disqualifiers, but they should be significantly shorter in duration. So I think what we're going to propose moving forward is those two pieces with some examples where we have some consensus. As you may recall before, as we tried to go through the list, it was just tough. I mean, there were a lot of questions, and we can continue to have that discussion with the large group, but in an effort to kind of be done today, we're going to come up with some examples of those two, and we'll open it up for discussion as we go. I know that's a little bit jumbled. Please, yeah, Ms. Evans.
So explain to me, so are you saying in the event that we don't go to a permanent, aside from federal and 5 years, that we're going to recommend this other thing as well? Like, I'm a little confused about what you're asking for, because we've already said that our recommendations are federal permanent, Adam Walsh, and then a 5-year disqualification. And now what you're saying is something that kind of contradicts that. And so help me understand.
Yeah, not intentionally. We're sticking with the framework of 5 years and permanent. We did not have consensus regarding what should beyond the 5 years and what should fall off. And specifically, we decided that we would go back and determine when the disqualification period began to make this recommendation. So we're not really deviating from that structure, but I don't think we had uniformity on that we're just following the federal Adam Walsh permanent list either.
Got it.
And I think we just don't have uniformity on that. So like Mr. Vogel, why don't you pull up the list of disqualifications, and we'll start going through on the misdemeanors, kind of where we were at before we kind of sidetracked and started talking about other things. So as you can see,
sorry, I should note, Mr. Chair, we do have Representative Robbins dialing in and Mr. Sandoval, so not everyone can see the screen for those purposes of this discussion.
Okay, and then maybe just anybody who identifies that I'm making a mistake and not being as verbal, let me know. And we'll make sure that we discuss it. So the list I'm looking at right now is a list of the misdemeanor offenses that are currently listed under 245C as 7-year disqualifications. And for example, wrongfully obtaining assistance is currently a 7-year disqualification. During prior discussions, we had a majority of those weighing in agree to remove wrongfully receiving assistance as a disqualifying crime. So a misdemeanor for wrongfully retaining assistance would, our recommendation would be to remove it because it didn't have a direct correlation to the safety. The numbers are not huge, just 46 of those individuals who were disqualified in 2018 and 64 disqualified in 2019. We also made the same recommendation to remove just for the misdemeanor level of a fraud. And frauds are very low numbers, criminal fraud. It was less than 10 in 2018 and 0 in 2019. We recommended removing federal SNAP fraud at the misdemeanor level. And again, in 2018, there were 0 cases, 2019, 0 cases. And then we started having some division about where certain offenses should be. Should they be under our scheme a 5-year disqualification, a permanent disqualification, or no disqualification? What we ended up on all the misdemeanor levels was really the max misdemeanor level would be a 5-year disqualification. And I think the idea was it was 7 now. The subcommittee felt that the 7 years was too long and not consistent with federal law, not consistent with other states. And for the misdemeanors that remain, they'd be 5-year disqualifiers. The ones that were listed as remaining would be criminal vehicular homicide. Those are low numbers. And again, these were 7 years before. So we're not taking something from a 15-year. These are misdemeanors, so that'd be pretty rare. The 5 different types of assault were all remained on. The domestic assault remains on at 5 years. Financial exploitation, vulnerable adult remained on. Failure to report maltreatment of a vulnerable adult, which again, very low numbers, remained on. Assault of an unborn child and coercion and violation of a protection order all remained on. And then we ran into some questions I think we need to start talking about today is what do we want to do with medical assistance fraud, theft, bringing stolen goods into Minnesota? Mr. Vogel, could you scroll down just a little bit more? Maybe up a little bit more. Okay, yeah, so I was just starting at about, so bringing stolen goods into Minnesota, these sort of yellow or orange colored ones were the ones we did not have any consensus on. Are there, and I feel like I'm just talking a ton here, everybody, are there offenses listed here that individuals think should be removed?
This is felony level theft only, correct?
No, this is just the misdemeanor.
Oh.
So we're looking at just the misdemeanor level stuff.
Well, I might be an outlier, but I mean, I've seen misdemeanor theft be a package of Hostess Ho-Hos. You know, oh, last week it was a package of diapers. This is small fry, and while it's not a good thing, I think having that be the only thing that stands between that person and employment would be a bit of an irony when they couldn't afford to buy their diapers.
Others have thoughts on that. And the statutory expungement period on a misdemeanor would be 2 years after completion of sentence.
Yeah.
I would agree with it being removed. I mean, especially given that context of the expungement law would be even less for that misdemeanor level, as well as medical insurance fraud. I feel like that could be removed as a disqualification.
And this, of course, does not prohibit any employer from looking at this information and making an independent decision. This is just whether the state disqualifies this individual from any ability to get the job. I mean, there certainly could be a set aside, but
yeah. And I think this is where we really hit the narrative hard, right? Is that, this is where we give employers the opportunity to make decisions for themselves, right? The return on the investment for employers, the state is not stepping in. This is employers being able to have some leeway to make decisions about that. And, if somebody has one, the employer can make a decision. And if somebody has 5 of them, the employer can make a decision. And where it gets to be more risky is when the state steps in and has some time frames on it. And so
It's a really great way to frame this, because when do we really need government intervention?
yes,
And I would think that there's got to be among everyone on the political spectrum, nobody wants more government involvement in private business than is absolutely necessary. And yeah, it bears repeating that this doesn't mean it's a guarantee that criminal conviction will still be something that an employer will ultimately know about and can decide. And if it's a misdemeanor theft and they're going to be working in a daycare with no access to funds, maybe they decide, yeah, there's enough great qualities in this person to hire them.
Which goes back to Dave Irvin's conversation very early on of working with people, developing relationships with them, and being able to make a decision which was in the best interest of their nonprofit, whether to hire or not, and being precluded from it. And the way I look at the statute is, let's make sure that there are some things that there's just no chance for people to have access to our most vulnerable populations. But for the vast majority, it needs to be a case-by-case basis, and employers need to be a part of that. So let's theft is the big one in this, because the numbers, it is really the number one disqualifier of individuals on a misdemeanor level.
Yep. The other thing we haven't talked a lot about during our time together has been volunteers. And we have a lot of volunteers that get disqualified. And, we want them to come mentor. We want them to come run with our clients. We want them to do all of those things. And, sometimes it's these kind of things that keep somebody from being a mentor, and they have zero access to our clients' things, zero access to, they just want to come eat lunch in the cafeteria with a client and have a conversation. And so and we haven't even talked about that kind of stuff, but even our volunteers have to pass these rigorous background studies. And so that's a whole nother component of this.
Yeah, there's no difference under the statute between an employee and a volunteer. Well, we've heard some people who are in favor of removing theft. Are there people opposed to it? How about medical assistance fraud? Ms. Kaser added that as a possible, and we don't make these decisions. These are going to just go to the full task force, but the medical assistance fraud, do people have concerns about that just on the misdemeanor level being removed? And you can see the numbers are non-existent. There's zeros.
I think between the zeros and the fact that, again, if a potential employer has a concern, don't hire that person. If the job just has too much control over finances or access to it, and you're not sure, I love keeping that in the employer's hands. They know the job they're hiring for better than anybody.
Agreed. Mr. Vogel, why don't we turn 17 and 18 to blue? I think that was the color you were using. I apologize. No, yeah, that kind of, I can't even describe those colors. They're so bizarre.
I'm going to go with puce. What do you think
God.
about that orange color? Puce.
I think that's right. Here's another kind of zero, bringing stolen goods into Minnesota. What are people's thoughts on that? Again, zeros and these no disqualifiers.
I have a little bit of problem being part of a very organized sort of crime system. It's, in my world, so different than my woman last week who stole a package of diapers. Because that is, even if there is a questionable reason that she's out of money, she's still stealing this one thing for a really legitimate purpose, and is not part of somebody stealing something in a different area only to move it out of there. That level of organization and intention is a little more bothersome, but I'm open to being talked out of that.
And how often do you feel like it's organized like that and not just like she stole it in Hudson and drove to Stillwater? Like, because what we're talking about here is zero times. Are we talking about zero times?
That might be more common, but I see it more with people who want to get in the way of a successful investigation and get it across state lines in hopes that the law enforcement agencies aren't coordinated enough.
Yeah. And again, I'm going to go back to, like, I really thought about this because I was more on the other side of this for a while there. And when we're talking about less than $250 and less than $500, and like, I feel like letting us as an organization decide that we're willing to take the chance on somebody that tried to do this for less than $250, and letting business decide at this level of risk that we're going to just let business
Ms. Evans,
take care of their business.
I stand convinced, Ms. Evans.
Is anybody opposed to moving, bringing stolen goods into Puce?
No, I'm in agreement.
I am too.
Puce is the gold color then.
There it is. My recollection on identity theft was we were at this point leaving it in, that it had a significant disruption to people's lives and it made sense to leave it in. But certainly I want pushback if people think differently. All right. Another big one in Minnesota for the 7-year disqualification was the issuance of a dishonored check. The numbers are in 2018, we had 200 disqualifications, 2019, 359. That's a pretty high number. If you just look below, insurance fraud under 10, dangerous weapons, 19 and 27, 0 on spring guns, 0 on interference with privacy. So, my recollection too, and I would ask Mr. Vogel and others if they recall this too, almost all the issuance of dishonored check cases result in a set aside.
As I recall, Mr. Chair, that's correct for issuance of dishonored check cases where they applied for a set aside in the first place. I can pull up the precise statistics if you'd like.
Yeah, I think that's really important too, is that in the high 90% is my recollection, but again, I'll defer, that even though these were originally disqualified, they were all set aside.
Yeah, it was like 96% or something. Yep.
Let's see.
You're right,
here.
John.
Wonder why bother?
That would be my thought, is why should we have and then the bother too, of course, is the delay, the low numbers of people, the disparities that come with it. So I think that
Use the resources when people have to still look at the paperwork and yeah.
And the amount of people that don't apply for a set aside. So you're talking about like 70% more of people who would have been employed had they applied for a set aside and didn't bother because they didn't feel worthy enough or didn't want, like, that would have been employed. And so when we're talking about workforce and small business and getting our economy back online, like that's another 700 people that would have been working or could have potentially been working if they didn't have to do that. And so I feel like for that one specifically, like, and it's like a crime of poverty, right? They're writing their own check for less than $250. I feel like it's one of those that with all of those things, like that's the narrative, right? That we just talked about. In my opinion, we should just get it off there.
Does anyone object moving issuance of dishonored check to PUSE?
Nice color choice, Will.
Yeah, well.
I don't object, but I just want to point out that might be a good example one to show some data of, especially the fact that on reconsideration, 90%, were. So it just gives us legs in terms of why we would want to remove that one is a thinking.
I think that's a great idea in this case. And Will, could you just sort of note that as we write this next page, this would be a good one to use numbers, use some of the data that Ms. Evans talked about, and then the set aside data to show, I think those are all really good points.
A good case.
Yeah. And again, our list might not be exhaustive. It's going to be some examples. And I think showing how we got there is important. Insurance fraud. It's a low number.
I'm not touching that with a 10-foot pole.
Let's leave it then. I would say the same for dangerous weapons and spring guns. I don't think spring guns are a big deal. I shouldn't say I don't think they're a big deal. I don't think they're zero, but anything that involves weapons might make sense for us to leave in the 5-year unless people disagree. Yeah.
Just because they're being what is the word I'm looking for? People think they're like law enforcement and stuff is thinking they're real guns and people are getting hurt. Right. And so.
Well, a spring gun is a mechanism, I believe, that is like an automatic gun. Like you open the door and the gun.
That's right, John.
The gun shoot you.
You can even be absent. You can even be absent from your home, but you can set it up so that somebody walks in your door and the spring gun will fire, which of course is problematic when you have somebody with an emergency who's simply trying to, get away from.
And it fires a bullet?
It can.
Yeah.
Jeez.
There's usually some type of rigging system in these. I don't know if it's something that's marketed, but something designed. You put it at your cabin, so in case anybody tries to break in, it shoots them.
No. Inspector Gadget.
Yeah, exactly.
Right, Leo?
Interference with privacy. We have 0 misdemeanor disqualifications, which I think there's 2 arguments. One is if you have 0, what's the harm in leaving it in for appearances? The other point would be, why do we have things that never appear? So it does involve the use of a device to watch a person.
Yeah, nope. If it's dealing with people's privacy, it makes me think about people with bad boundaries and youth. And if I just leave it, it's not great.
Does anybody disagree with that? Okay, so why don't we leave that in? And then we have the harassing telephone calls and letter, telegram, package harassment. The numbers on the telephone calls are 11 for 2008. 2018 and 21 for 2019. So they do exist. Well, we don't see any of the other packaging.
What do you think about telephone calls, Judge?
Got an issue. That's the sort of bullying control stuff that is an offshoot of sometimes domestic abuse. It's just domestic abuse light or neighbor abuse, but the harassing, obscene telephone calls, that troubles me. So I would still like to see a 5-year on that. That's a sign of something way worse.
Let's leave them both in. It doesn't make any sense to remove one and not the other, even though there are none. And I understand that. What about fraud in credit? Obviously,
What are the
numbers are 0.
As a misdemeanor, I'm not that concerned. I want to leave it to the employer, and we've got no number. We've got nobody.
I feel like that about the financial transaction card fraud too. What is the like amount on it, or is it charged out differently? What's the difference between gross misdemeanor and misdemeanor financial transaction card fraud?
Probably 500 and 750.
Yeah, there's no number. It looks like it's.
Yeah, I don't know if it goes under the regular
I
theft.
thought you meant what's the difference and between a gross misdemeanor and misdemeanor. Sometimes it's
Yep, it's the money, but it doesn't say that in here. It looks like it's about behavior, right? Is that what this is reading?
The fraud is
Oh, I'm reading the wrong thing.
misrepresenting to get a loan.
Yeah, I'm talking about the financial transaction card fraud, and this is wrong. It says something about lewd behavior. I'm like, this doesn't look right. I don't think that's right.
Yeah, that is not.
All right. So it probably is money, right? Less than $250.
Yeah, it's going to be money. I don't know what the dollar amount is.
Do you have your fancy book, Judge? I just would like to verify that that's what it is. And if that's what it is, like $250, I think we go back to.
Okay, give me the number.
609.82.
609.82.
Oh, that's a lie. 821.
609.821. Here we go. Financial transaction card fraud. We got definitions. Person who does any of the following commits financial transaction card fraud without the consent of the cardholder, knowing the cardholder has not given consent, uses or attempts to use the card, knowing it to be forged, false, fictitious, or obtained in violation of something else, sells or transfers the card. The sentence. Let's see. Maybe sentence as follows. Well, if the value of the property was more than 35,000, okay, 25,000 is a felony, 10,000 a felony. A gross misdemeanor if more than $250, a misdemeanor if under that.
Got it.
I mean, if we're taking theft off in those lower numbers, it would seem to me that it would make sense to do the same for this. Leave it with the employer to make the decision.
Yep,
I
I agree
agree.
with that.
Can you make that change, Mr. Vogel? I'm just gonna put out there that the indecent exposure and harmful materials that involve minors will remain in. Does anybody disagree with that? I'm gonna assume we're gonna remain with the violation for protection orders as well. Remain in. I will also assume all the maltreatments. I think there's a recommendation coming from remedies because it is unlike all the other cases. The maltreatment cases are all preponderance of evidence cases. These are non-criminal convictions. Person doesn't have a right to an attorney, doesn't have, oftentimes people don't go to hearing on these. You don't have the right to cross-examine an adverse witness. It's a pretty different kind of case. So do we want to weigh in on the maltreatment cases now, or just sort of put those on hold? Because again, we're not coming up with a complete list, but the maltreatments are. Please go on.
Sorry, John, this is Lucas.
Hi, Lucas.
Hi. Sorry, everybody, I had court and I'm still driving, so I
No
had to
problem.
call
We
in.
appreciate it.
So I can at least say the remedies for the maltreatment was, so first of all, for the DQ, it has to be serious or reoccurring. And so what we proposed was right now for maltreatments, it includes not only investigations, but also family assessments, which family assessments themselves are actually not even appealable. And so our recommendations were going to be that disqualifications based on maltreatment can only use investigations. It cannot use the family assessments. And that an individual, even at the disqualification level, would still be entitled to a hearing on it, including looking at the underlying maltreatment itself, which right now, even if it's a disqualification based on a maltreatment, they consolidate them anyway. So the maltreatment is already combined with the disqualification itself. I think that's the substance of essentially what remedies is proposing. We're not getting rid of it, just trying to make sure there's enough protections in place, recognizing it's a different process.
Sorry about that. We could sort of piggyback on that and kind of say, we're saying leave them in subject to remedies qualifiers. Does anybody have any concerns with that? I mean, we'll be able to iron out kind of the overlap in the full task force, but are people okay leaving in maltreatment cases as what would be a 5-year disqualification? Which does lead to one question, when we were doing, when does a disqualification period begin? Our entire thing was based on convictions. We have it as the date of the incident for a conviction without an individual being committed to corrections. Are we in agreement then that for non-convictions, specifically maltreatments, it would be incident date as opposed to any other date? Seeing nobody taking any objection, I'm going to write that in as a change just to indicate that the way we wrote it, it just said conviction. So I'm going to modify it to include that. Okay, let's move on. Let's go. Will, can you pull up our list of felonies?
This is a bit of a rougher list, Mr. Chair. I apologize, but I can pull up statistics as needed.
Yeah, I think what we're trying to do today is come up with some on the list of felonies that we do not think should be permanent disqualifications and should fit within the 5-year. And Ms. Evans, I would think we might want to start with the 152 drug cases. Those were very high on the list of recommendations from the original disqualifying task force in 2008 to reduce the severity and length of disqualification for these offenses. What are people's thoughts on that?
You're kind of serving me up a slow curve there.
That was my goal, man. That's me. That's how I always pitched, hanging curveballs.
Well, again, I think people become addicted and have controlled substance crimes for many different reasons, but to have that be a lengthy disqualifier is, I think, inordinately punitive if they're trying to turn their life around. And part of trying to turn their life around is to be able to obtain gainful employment. I guess I'm an exception. I didn't have to go out and sell drugs to make a living. I already had a great job. I just screwed that up with my choices. But I really do feel that people that are trying to get their life in order and trying to gain employment somewhere that have had, and I don't care if it's 1st degree to 5th degree, to me, it seems that especially if they've been through treatment, there should not be a lengthy disqualifier. If I were subject to my disqualification without having had a set aside, I still wouldn't be eligible to work. And I've been employed at Team Challenge for over 5.5 years. So, I mean, I would hope that other people get a similar kind of chance, and people who are less fortunate than me, I think deserve that chance.
The vast majority of cases I see are 5th degree, and the probation period on those is only normally 5 years. And some of them are even stay of adjudication. So after 5 years, not only are you done with supervision, the case gets dismissed. It seems ironic that, a defendant can prove themselves to be amenable to probation, that doing what they need to do. And after 5 years, we're going to prohibit their employment in all these areas. So I'm all for the 5 years, especially on both gross misdemeanor and felony 5th degrees.
Yeah, especially if there's been no further criminal behavior, right? That's what we're talking about is the behavior, right? We want them to discontinue the behavior. And so if they haven't had any additional criminal behavior since then, and that's what the initial background study does, that DHS does when they're looking at people's applications. And so I think we're doing as DHS is doing their due diligence with the initial part of that study without having to do if somebody hasn't committed a crime in 5 years. I think we're pretty good.
And we can include this with some wiggle room, identifying that similar to the 2008 task force, we believe that the controlled substance offenses should not be, a permanent disqualification and should be in line with the 5-year disqualification. I think there are some questions, if we get in the nitty gritty, with maybe today we don't, but the 152.137 methamphetamine related crimes involving children or vulnerable adults.
Yep.
I think there is still some stuff we want to iron out, but I think we could say in general terms, we want to see changes in the 152 laws. Are we in agreement on that?
Yeah.
Okay. Anybody disagree with that? Any thoughts on what we should do with the next 50? We have 50 other felonies. Do we go through them and see if we have like kind of like visceral responses to whether they should be these are all felonies, whether they should be 5 years or whether they should be permanent? Again, looking to find ways to come up with other examples and lists to provide to the larger group. And are you guys up for digging in for a little bit, or should we spend a couple minutes and look at them? And I mean, wrongfully receiving public assistance seems to me to be a 5 year.
I would agree.
Fraud, 5 year.
Yep.
Same with SNAP benefits. I don't know, a felon ineligible to possess a firearm.
Yep. So somebody's gonna, and here's where my sensibilities, I have a little bit of a hard time because you all decided that it's 5 years from the crime, and somebody's going to do 5 years on that. And so they're going to get out probably with no treatment, no therapy from prison, ready to go, ready to get a job working with vulnerable adults. And
So
I
if they
just,
if
I
they go
can't
to
sign off
prison,
on that.
yeah, if they go to prison, then the period doesn't start until they're released.
I know, but still, that's same thing, John. What's the difference?
Okay. No,
Ms. Evans, I think I can explain it well, and I agree that we're going to differentiate between people who are just on probation and people who are in prison, with the understanding that when you're in prison, you're so supervised, you couldn't break it's a little hard to break the law.
So the 5
So
years
with those-
doesn't start till release?
Correct.
Got
Yes.
it. Perfect. All right.
Yeah.
All right. That makes sense now.
And you know, I one of the hard parts about 5 years and permanent is it's another arbitrary distinction. And there are some you're like, man, is that one in the middle? So if we don't have consensus today, that's okay. Because I think felon ineligible to possess firearm is a tough one. I don't know.
So I was thinking you guys were, yep. So that makes better sense to me now that.
And we ended up mirroring that because that's mirroring the language in the child foster care rule.
Mhm. Yep. Yep.
So
I
it's,
tell you, felony in possession, I am really uncomfortable because every time I see that, that person's been busted for something else too, and they have no business having a firearm, and they have one. And yeah, that kind of spells antisocial, violent potential trouble.
Well, they have
that's-
mandatories on that one, right? Where they're going to do 60 months. And so they did 60 months. That's 5 years. Plus they're going to have to be out another 5 years. So you're talking about 10 years at that point, right?
I think for today's purpose, we just sort of leave it as it's not one of this low hanging fruit that we're
Okay.
moving. I have never been, I would say criminal vehicular homicide and injury would be another one that's not low hanging fruit.
Hmm.
And those are a lot different. Assault, third. I think we just leave that one for now too. And then let's leave all the assaults for now. I think we should leave crime benefit gang for now. Criminal abuse of a vulnerable adult, we're not touching now. Financial exploitation.
Yeah. Down
We're
to
not
simple
touching.
robbery, John.
Okay, simple robbery. I don't think we're touching that either, are we?
Yep. False imprisonment. No. All
None of
the
those other
unborn child.
assaults.
Yep. Coercion. We couldn't get anywhere with that.
What about the medical assistance fraud?
There we go.
Can we agree on medical assistance fraud being a 5?
Yeah, I can.
How about felony theft? What are we saying about felony theft?
Well, it's
Yeah.
the same thing, but bigger numbers.
And the numbers can get pretty big.
Mhm.
Let's leave it for now. How about possession of shoplifting gear? I'd like to take that one down.
Yeah, 5.
Bringing stolen goods in Minnesota, 5. It's at the
Yeah.
felony level. We okay with that?
I
Yeah.
am.
I am.
Yeah, we
about-
couldn't.
If it's receiving stolen property, 5.
I'm
it was-
okay with it.
How
I'm
about
okay with it.
issuance of dishonored check, 5?
I've,
And then I think we leave the arsons, the burglary. Yeah, what about possession of burglary tools?
How many are there of them?
I don't.
Do we have that in there? No.
44 in 2018.
Yeah. I think drop it down to 5.
Okay.
Anybody disagree?
nope.
I think with some of the thefts and the fraud and the forgeries, I think we got to leave them for now, because some of them can get really high numbers, just so we figure that out.
I know, but if the harm wasn't high enough for them to go to prison,
You convinced me.
right? And
Yeah,
then if they did go to prison, they do their prison time and it's
Yeah.
5 more years after that, right? So I feel like we've kind of built in this
Agreed.
system, right?
agree.
Didn't we? What do you think, Judge?
Agree with you. Yeah, you got a 5 and add another 5.
Right? Either you're the guideline commission, either the sentencing guidelines, you're right. Either you don't pose enough of a risk of harm that you're in the community, or you have to do your time and then 5 more years.
Yep.
Yeah, I'm with you. Thank you, Miss Evans. So I think insurance fraud, aggravated forgery, check forgery, offering a forged check, all go in there. I don't know the crime obtaining
Nope.
signature by false pretense. I don't know that one.
And I feel like that can get into like vulnerable adults and like coercion. And
All
I
right,
think we
let's
should
just
leave
leave it.
that one. Leave dangerous weapons, machine guns, adulteration, like
Yeah.
terrorist
Fraud and
threat.
obtaining credit. I think that's consistent if we include that in the 5-year. Same
I
with
agree.
financial transaction fraud.
No indecent exposure, obscene
Yeah.
materials, none of that.
All right. That's the
No
list.
firearms. Wait, what was that last thing for alcohol? Oh yeah. Felony level conviction involving drug and alcohol use. What's that? Oh, that's just an explanation of the 152 crimes.
Yeah, I think we'll do a general one for the rest of those.
Okay. And those are kind of the people crimes that we talked about to begin with, right?
Yeah.
Is what that ended up being.
I think we're just sort of using these as examples, and again, consistent with what the 2008 group did.
Yeah.
Is
Well, and just
Go on.
looking at it right now, John, it really is. When we went, I mean, the time that we spent going through the list and doing people, property, drugs, it wasn't a waste of time, because here we are back. You look at this list real quick and here we are back. That's all them crimes that we decided were, except for the theft that we didn't mark in blue. That's all. I mean, we decided identity theft had that enough that it was like it affected people's lives in such a way that it really was more people, or as much people as property. But the rest of it, that's all we came up with, people crimes. And so
So this was the last piece with the group's approval. I will synthesize this into our bullet points and disseminate it in the next day or so. People okay with that?
Yes.
Absolutely. Yep.
All right. I didn't think there was a chance we were going to get this done this efficiently and wonderfully. Any questions before? Any last issues? Anything else, Will, that we need to address with the group?
I don't believe so, Mr. Chair. The group was examining gross misdemeanor crimes previously as well, but I think that's a very similar list to the misdemeanor crimes.
Yeah, I think we're gonna with the groups. I'm just gonna take what we've been doing and slide pretty much everything over and get it done. Are you guys okay with that?
Mhm.
Okay. With that, seeing no other questions, issues, we'll let Mr. Sandoval hop on a plane. We'll let Ms. Dawson drive home safely. And we'll
So
let
then
the
do we
girls
have,
go out to dinner.
do we have a list of recommendations then?
We have our list of recommendations in bullet point format. This was
Perfect.
the one piece that was lacking. I did write the section that we put together from when Ms. Kaser led us. I've changed this a fair amount, Will, just so you know. And I filled in all the yellow spots. But I will disseminate it and in case anybody has feedback prior to further distribution, if that's okay. So I'll get it to you, Will, and then if you can get it out, we'll give people a deadline before we send it out to everybody.
And is this what we're going to cover Friday at the meeting?
Yep.
Okay. Are you going to be there?
I'm trying, yes.
Okay. Otherwise, if I could know that so that I can look it over and be
I'll know
prepared for
tomorrow.
Friday. Okay.
All right.
All right. Perfect. Thanks, everybody. You guys rock.
Yeah.
You do.
John, you cause her heart palpitations when you're not there and she has to present.
Well, I can
get it.
always delegate to you, Dave, and give you.
No, I like that Gina does it.
It's fun to watch
She's
her
very
squirm.
convincing.
It's not my favorite. Not my favorite.
All right.
Bye, everybody. Have a good
Bye.
night.